Hello, and welcome to today's webinar, HR and Payroll Record Retention, presented by our sponsor, Heffernan. We're so happy you can join us. My name is Deb Beto, and I will be your moderator today and be monitoring questions you may have during the session. Before we open up the session, let's review a couple of key items. All of the webinar materials we discuss can be found at aspenrmg.com/Heffernan webinars. I will be sharing this URL in a follow-up email, so don't feel like you need to write it down right now. If you have trouble with your internet connection during the webinar, we recommend leaving the presentation and logging back in. If you have audio difficulties or a telephone line goes dead during the call, hang up and call back again to the same number. If all lines go dead, watch the on-screen chat box for an alternative call-in number. Please feel free to ask questions or provide feedback by using the chat box during the webinar. If you are using a tablet, you may need to tap on the screen for the options bar to appear, and then you can select the appropriate option. We may not respond immediately, but we will work your questions or feedback into the presentation. If we can't get to your comment or question during the session, we will be online afterwards to respond, or we may follow up in an email if we run completely out of time. You may also email us at moderator@aspenrmg.com for up to 48 hours after the webinar. This will be a 1-hour presentation. Questions and comments are very much encouraged throughout, and the presenters will be answering questions at the end. And lastly, we have a number of webinars upcoming covering a variety of topics, including those listed at the Heffernan webinar website. In addition, we offer the mandatory Preventing Harassment training in English 3 times a year. With that, let's begin today's webinar, HR and Payroll Record Retention. So I'm going to turn the screen over to our presenter while I introduce you to her. Today's interactive session will be facilitated by CJ Westrick. CJ Westrick is an SPHR and has been in human resources management for over 25 years and has worked in companies with 25 to 1,750 employees nationwide. CJ received her SPHR, which is Senior Professional in Human Resources certification, which is a national certification, in 2002, and she has a bachelor's degree in business management. She started HR Jungle in 2006 and targets companies who want senior-level HR expertise on a part-time basis. HR Jungle provides business owners and management teams workable solutions and hands-on assistance with employees and legal compliance through outsourced HR services. With that, I will turn the presentation over to CJ. Thank you, CJ.
Thank you so much for that. And so today we are going to be talking about the laws that require retention of records and the different categories of records and what do we put in each category and the various timelines for them. So I always like to see if I can find any kind of little news stories that are out there that relate to the webinar I'm doing. And these are a little bit, I mean, there's nothing that really points directly toward record retention per se, but it is part of record retention. We have Zales had to pay at $1.8 million because employees said they were shorted on their wages. So, and it was based on a time rounding policy. So that means they were looking at their payroll records, they were looking at the pay stubs, even their policy on what their time, their rounding policy was, because I know that has come under fire at times legally in different states. So this one turned into a class action, which is another reason is 1.8. Then we have La Fiesta Mexican Grill. Alleged sexual harassment. They had no sexual harassment policy or employee complaint procedures in effect at the time. And again, I don't know which state you're in, but some states require a sexual harassment policy. And it always pays to have that regardless of what state you are and what the state actually requires. Because in this case, it worked against them. They had to pay, $25,000. They had to implement the new policies to conduct training. And that $25,000 is kind of the low end of what I'm sure they had to pay, because they ended up having to pay for an attorney for a very long time to handle this case. And as you can see, they're having to report to the EEOC for 3 years. And so it has some long-term effects when the paperwork isn't done right. Then we have Philadelphia, a commercial printer, paid $31,000, a little over $31,000 in civil penalties, but then almost $274,000 in back wages and liquidated damages to temporary workers who they found had shorted, again, wages in violation of the federal laws. So, the paper really, in HR, it all really always comes down to the paper. What can you prove? Then this one was still out, I think, at the time I did it. Let me see if I got. But oil states, they again failed to pay overtime wages to the operators. They were paying them a salary and a job bonus instead of paying them hourly with overtime pay. And they didn't have anything to back it up to show that these people should be salaried or a job pay plan for the crane operators. It was really kind of just messy based on the way the judge wrote it up, in the sense that, they didn't have a lot in place and they ended up getting slapped for it. So this is why, it's not only retaining the records, but making sure the records are even there to retain. And the last one I'll mention is the University of Denver, $2.66 million. Again, a paid discrimination lawsuit. We have federal laws now, we have some state laws that talk about equal pay. And you need to be able to justify a difference in pay for people along the same, level of responsibility, level of authority, job duties, things like that. And that all comes back to holding onto the paper. What is the justification? Did you even do it? So it really goes much deeper than just what do you have in your file. It's what do you have altogether. And keep in mind, every time something like this comes up, I will guarantee you there were employees that were keeping records that may have even been better than yours. So don't think that, oh, they're not paying attention. I've had employees contact me that are quoting. You can hear them reading from the paper that they've been making notes. Well, he said this on this date and at this time. So it's important that you keep your records too. So let's start in with the first polling question.
Okay, let's launch that. First polling question, how many agencies dictate record retention? Is it 3, 5, 8, or more than 8? And while you're answering that question, I'll just remind everyone that all of the webinar materials, including the PowerPoint presentation, can be found at aspenrmg.com/Heffernan-webinars after the session today, and we will be sending this URL by email, so don't feel like you have to write it down right now. I just want to let you know that, because we've had quite a few questions regarding that already. Okay, so our polling question says 24% say 3, 39% say 5, 8% say 8, and everybody else, almost 30%, say more than 8.
When you start looking at it, it's quite amazing who has a voice in your record retention. It's everywhere. We've got the Fair Pay Acts, we've got state labor codes, the NLRA, you've got ADA. It's like, it feels like it's never ending here with the amount of people that might have a finger in your files, or that could ask to look at your files or your policies to see what you've got. And that's why it is important that you have proper record retention and the proper records to go with them. So let me find out just what you're doing with your files. Let's go with the second polling question.
Okay. How many files do you have for each active employee? Do you have one big file, up to 4 files, or 2 files? Okay, so I'm going to wait until about at least 80% of the people have answered, because I want to make sure that everybody is participating. And we've got about 73% right now, so we need just a few more people to put in their vote here. And CJ, the answers that we're coming back with, 14% say one big file, 43% say up to 4 files, and 42% say 5 files.
Okay. And as you all heard, there's a lot of variance out there. And it's, you know, I think you should have at least 4. But I will say that I know smaller companies usually have just one big file. But even then, you need to be careful about what you're putting into it and to separate it out. Because when you look at these, there's the general file. Here's all your recruiting materials. Here's perhaps their performance reviews, things like that, that are the general things that most of us have in the files. But nowadays, with privacy laws and such, you need to start breaking out some of those documents if they're in a file. Medical file. It used to be because of the way the enrollment forms went, even for insurance, it was recommended that your insurance enrollment forms went into a medical file, just in case there was some medical question that the person had put on there. And I don't see that as much anymore because of the ACA removed some of the stipulations of prior medical issues. So now enrollment forms usually don't include that, but keep that in mind, take a look at that. But in a medical file, you want to break out things like any workers' comp claims or any doctor's notes, things like that, you know, leaves of absence that go in there that are medically related due to the privacy laws. If a supervisor wanted to see the employee's file, they shouldn't be able to necessarily see the medical file because it doesn't really relate to whatever they might be looking for. And then there's the legal file. If you've had to talk to your attorney about this employee at some point, all of that paperwork or anything that you've got related to that particular conversation or issue should be in its own file too. And again, to maintain the client-attorney privilege. And because if you put them all together, it's open to anyone who wants to look at it. And that could be breaking some laws in your state. Then we've got the I-9. And that has always been recommended to keep it in a separate file. Usually I tell people, particularly with small companies, either to, you know, put it in a folder of its own that all the I-9s are kept in, or I used to keep them in a binder so I could put them alphabetically and make it just easier to find what I was looking for. But that too, because if you ever got an ICE visit, you want to be able to only pull out the I-9s. If they're mixed in with your other files, your other documents in an employee's file, then you have to hand over the whole file. And while it may not hurt, why give them any information that they don't absolutely need? They're looking for the I-9 proof of eligibility that the person can work there. And so that's all you have to legally provide them. And so you want to be able to separate out this stuff because some of it won't be available to anybody who wants to look at it. Even the employee looking at their own file may have restrictions on what they can see. They would not be able to see what's in that legal file. The medical file wouldn't be a problem, but you know, again, you want to pay attention to that and figure out how to keep this information in places where you know this is where to go get for this thing or where to file that. But I always recommend having some kind of a standard for what the filing protocols are. You know, that you've got a list of all the different documents you've ever seen, and it's like, this is where they go, you know. And if you're using those big folders that have like the little inset tabs on them, you know, even that, I've done lists of saying, okay, here's what goes on the first side, here's what goes on the second side, and the third, and the fourth, and the fifth, and things like that. And, you know, when you're ready to, when the person is terminated and you're kind of cleaning up the file, you have to know legally what you need to hold on to in there. But you need to kind of pay attention to what it is. I've seen a lot of my clients that's just dumping every form in there, and it's almost basically chronological because they just stick the latest piece in there, including time cards and stuff like that. So kind of think through why you're holding on to those files and what should be in there versus somewhere else. Another polling question.
Okay, let's get that launched. So, are your files confidential? Your choices are I either keep them in a locked file or they're in a locked office, but the file cabinet doesn't lock. Both the office and file cabinet are locked when I'm away, or I just don't worry about it that much. And CJ, while they're answering that question, we did have one question come in. If it, Is it okay if we have copies of I-9s in the employee file, or should we file them separately if we are waiting for the original to come back to our corporate office?
I'd probably still keep them in a separate file and just have a note sheet that, like, here's documents you're still waiting to get. Because whether it's an employee needing to return a form that they had to sign or something like that, I think, you know, you want kind of a moving list of here's the things I still need to chase down.
Okay. So as for our poll, 38% keep them in a locked file. 12% say they're in a locked office, but the file cabinet doesn't lock. 50% say both the office and file cabinet are locked when I am away, and 0% don't worry about it that much.
Well, I'm glad people at least worry about it. I cannot tell you how many times I have gone into a new client's office and they've got unlocked, unlockable even files right out there in the main, I won't say lobby, but it's in their main, you know, like where the HR person is, but there's also the operations person and the bookkeeper and things like that. And they've just got them sitting there and think that that's, oh, it's like, oh, yes, I know I should lock them. And, but they don't even have a lock on the cabinet. So they can't just punch it in. And having them just in a locked file is a big step forward. I like them in a locked office with a locked, you know, the ones that had them in a locked office, but the file didn't lock. Consider the fact that you usually will have cleaning people coming through and unlocking your door, going in and cleaning your office and leaving. And then you're trusting them to lock it up again to keep those employee files confidential. You should always, you know, make sure that your cabinet is lockable, you know, wherever you're keeping the files. And if they're in a room that has a lock on it, I would keep the door locked also, even when you go to lunch. Even when you go out to meetings, at the very least, get in the habit, if you're having to go to somebody else's office for a meeting, that you reach over and lock that cabinet. And because I've seen too many times where that doesn't work. And also pay attention to what you're putting them in. I remember one time that was kind of a shocker for me. We had some new office furniture and I was getting this, you know, credenza kind of thing that was a filing cabinet. And the operations guy came in and gave me the key, and then I started looking at it and I started thinking about it. And I went to the other people that had new furniture, and it turns out that all of our keys were the same and all the locks they'd put in there, even though they'd been requested to have separate locks. They had used the same lock number, which means the same key works in all of them. And that happens a lot with even file cabinets. You get those 4-door file cabinets. If you're buying more than one at a time, you have to make sure that there's a different lock in each cabinet, unless they're all for you and, you know, you want the convenience of being able to unlock them all at once. But too often the manufacturers, they reuse these things. And so all you have to do is match up that lock number with the right key. So make sure that your lockable cabinets are truly lockable and unlockable only to you or the people that need to get into it. Because I think that's something that I would never have thought of it before that happened. And that was years ago. And so now I actually give it some thought. And even the old 4-door cabinets that don't have a lock built in, you can have them installed now. I've even seen where somebody has taken this iron bar basically and run it down through all the handles, and then they've got a way it padlocks up to the top of the cabinet. And, you know, so people get kind of creative when they have to lock an unlockable cabinet. But I think the ones that don't look at it closely enough are those that have a locked cabinet and don't think about, wow, did somebody else get this same key? So things to consider. So what goes into all these files that you've got? You've got in your recruiting and hiring pile, you've got your job applications, you've got resumes. I know in some places like in California, if you run an ad for a position, you are required to keep that application for 2 years. And I will say only once in my entire career have I ever had the state contact me asking if that person applied. That was back, I think, when it was a lot harder to get unemployment, because now they don't seem to bother to ask. They just give the unemployment. And but job inquiries into things like that, but kind of consider what you're doing with them. And I know a lot of that comes via email nowadays, or even through your website, because you've set up an application online that they can use. So take a look at that, and I have a tendency to keep them in a folder or a section of the cabinet based on the job itself. What was I, looking for at the time I got all this stuff in there? But when you're getting ready to hire, you've got other things. You've got your testing. If you're doing any kind of pre-employment testing, you might want to keep a copy of the ad that they originally responded to. And sometimes that, I know it sounds weird, but sometimes that's helpful if you're having trouble with the employee doing the job and you find out it just kind of went sideways from what you had recruited for, and that's kind of a clue to you not to use the same ad the next time. But look into the different things. A lot of states now have programs that will help people, help companies provide training. I've got a couple of clients that are using a state program where if they have the employee trained on how to use new software, they get reimbursed for quite a bit of the employee's wages. If you're doing, a promotion, you want to document that. Don't just give them a bump in salary. Looking, for job openings that you've sent to different agencies or to labor unions so that you can see, particularly if you're sending out to recruiters, because you want to know if that person sent in a resume based on you running an ad or even having it listed on your website, it's going to become crucial to have it timestamped when you got their resume versus when perhaps a recruiter sent you that same resume. Because if the recruiter sent it to you first, you're going to owe that recruiter money, even though you also received it later. So there's a lot of different reasons that you want to at least organize what all that recruitment and hiring paperwork is about. And you've got the offer letter, if you've got any kind of terms and conditions of employment. Normally, I'm not a fan of employment agreements per se like that. I like non-disclosure agreements, or I like to stick with what's in the handbook so that I don't have to worry that every employee has a different agreement of some sort. But in the file, in their employment file, you're going to want to keep like their application, their resume, perhaps what ad they responded to, their testing results, their, offer letter, and anything that you've had them sign. So you want to keep hold on to all that kind of stuff. And for the pre-hiring stuff, figure out what you're going to do with it once you've made a hiring decision. Some of it you may not have to hold on to, but some of them say that if you ran an ad, you have to hold on to the resume. But if the resume just came to you randomly, then you don't need to hold on to it. So kind of figure out what's particularly legal in your state regarding resumes that have come to you, and then deal with them accordingly. Background checks. Background checks, obviously in some states are getting messier because there's the ban the box in several states where you can't ask about criminal history before you hire them or make an offer at least. Things like that. Credit reports are much harder to conduct nowadays in many states because they have to fit a certain profile, and there's all sorts of little paperwork protocol you have to follow with it. But take a look at that and figure out what you're going to, what you're doing with it. Make sure you know what you're looking for in a background check and what action you're going to take if it doesn't have or does have what you're interested in. For instance, if you get a background check for driving, and you need to have the protocol in place, what your policy is for what to do with that background check. When I worked inside where we had a nationwide sales force and a fleet of cars, we had particular rules. If they had a DUI within the past 3 years, we would not hire them. If they had more than 5 moving violations in that same period of time, we would not hire them. So it was like you need to have that in place before you start looking for the information, because otherwise it's going to look very pointedly at the person you're interviewing rather than this is our policy. And you don't want them to come back saying, well, you just said that because of my record. Got our next polling question.
Okay, let's get this launched. And CJ, there's quite a few questions coming up that I'm going to go over in a second. So our polling question is, how long do you need to keep recruitment and hiring records? Is it 3 years, 5 years, or 3 years after termination? And a lot of the questions that are coming up are regarding keeping electronic files. It looks like a lot of companies are doing away with paper. Can we keep everything online, either in an HRIS system? Can you scan resumes and applications instead of keeping the hard copies?
Okay.
And then also when it comes to insurance applications, how long do you have to keep those in the file folder? Because the file folders get really thick because those insurance applications are really big.
And I know, and I'll get to the insurance ones later, so I'll cover that one. But
Okay.
the electronic, because I'm a big fan of the electronic also, I've been trying to unpaper my office, which can be hard to do. But with the employment files, yes, if you have an HRS where you can scan and put them in there or just drop them directly in there, that's fine. It doesn't have to be paper. But if you are putting them, I've had a lot of clients where they set up a special drive to keep all the HR stuff. So wherever you're putting them, again, look at access to it. What is the access? Because I know most HRS systems have to where even a manager, you can limit their access. They don't just have full access to everything that's in their direct reports section. That you can say they don't need to look at the medical records that you've scanned in there, things like that. And if you're just keeping them in a drive somewhere or in a folder, make sure it's password encoded in such a way to where other employees, other people that don't need to see it can't get into that folder.
Okay. And then regarding background checks, do you recommend doing background checks on volunteers?
I think it depends on how much they're interacting and with whom. Because sometimes volunteers are just doing backup things to help you. Other times they might be actively involved. I've got like a couple of nonprofits that work with children. And in that case, yeah, if you've got volunteers, I would consider doing a background check on them because you've got a lot of responsibility in protecting those children. And so you want to make sure that you haven't, brought in allowed a volunteer in there that's listed on the, websites as a sexual deviant or something. So I think you, again, want to look at what you're doing and why you're doing it when you come to background checks.
Okay, and last question about background checks. Does a manager who has a position open have the right to know about anything that comes up on a background check?
The privacy laws keep coming up bigger and bolder all the time. And so I would normally say no. I think HR should look at that and just tell them he's good to go. He meets our policy qualifications. Or, I'm sorry, you can't hire him because he didn't, fit the policy for our driving records. Something like that. But the manager doesn't need to know that there was a civil case because they went through a divorce.
Okay. All right. So the results of our polling question, 17% say 3 years, 9% say 5 years, and an overwhelming 74% say 3 years after termination.
Oh, all right. So it is 3 years after termination for the most part, but I throw this out there with, the whole caveat that, 3 years if you didn't hire that person. So that's that box of resumes you got that now you can send off to be shredded or something. But if you hired the person, I think you want to keep them at least 3 years after they've terminated. Or if there's a claim out there, if there's, look at what your state laws or anything are, you want to keep any of their records for as long as they could possibly come after you in a lawsuit. And I'll mention this probably more than once through this. I have attorneys that tell me there's no reason to ever get rid of them. If they were an employee, you scan them somewhere so you don't have to deal with the paper, and you put them somewhere where, as long as the company's in business, someone could go back and look them up. And also keep in mind that as we go through this, there are overlaps. We were just talking about recruiting material, but we'll be looking at some other of the types of things you have in the folders, and they might have a longer period of time, which is why it gets a little messier, and you want to hold on to them. I mean, we have to hold on to all of our business or our personal records for like 7 years for IRS. So why would you get rid of an employee record before then, once they're no longer active? So you do want to kind of think in the longest terms possible. When you're looking at your basic personnel files, these are the ones that I think everyone probably has or should have in a file for each employee. You've got the disciplinary notices, promotions, demotions, and when I say these things, it's because I like to see these things in writing. And if you're in HR, you know that certainly helps when it comes time to do a termination or even a promotion. I've had people where they don't look in the file to see things that went on or complaints that were filed against that employee, and suddenly they're wanting to promote them. So look at that, performance evaluations, their termination paperwork, or if they were transferred to another department, or even if they came back to work, you want to be able to pull up that file again. Training records, hopefully you're keeping some kind of a training record for each of them. And job classifications, whether they're exempt, non-exempt, their job description when they were hired or when they change positions is always helpful. And any terms and conditions that might have been in writing based on that. And I'll add to this, if you have an employee handbook, that they should have a sign-off that they acknowledge they received the recent one. And usually you're going to have more than one of those sign-offs for an employee handbook, because every time you update that handbook, they should have to sign off on it again. And this stuff has to be kept for at least 3 years after termination. But again, it's like, why get rid of it that soon when you might need it? Next polling question.
Okay. How long does your payroll provider keep your payroll records report / all of your records if you change providers? Is it 0 years, 3 years, forever, or any amount of time at a cost? We have a question, and I just want to kind of look at it here. It says, what if a manager is the one that hires people, not HR, and they decide to, quote unquote, test if the person is good for the job? They decide not to fill out the new hire paperwork. Should I, as HR, ask them to have the paperwork filled out even if the person didn't work out?
Yes. Well, in the sense that I know this sounds like what I hear a lot, where, we want to do a working interview. I'll have them work with me a day or two, and I'll just pay them cash or something for their time. And then if they do well, we'll go ahead and hire them. And, this is kind of outside of the record retention, but in California, that is illegal. If, an interview, if I'll have them do maybe a test, like a sample thing, like, show me that you can enter all this stuff into Word properly, and I'll take a look at it. But the working interview concept should be no more than an hour of your interview process, because longer than that, you should start paying them for that time, which means you need to put them on payroll immediately.
Okay. And the results of our poll, 4% say 0 years, 46% say 3 years, 20% say forever, and 30% say any amount of time at a cost.
Okay. Now, if you're in HR and you're not doing payroll, it's not one of those things you necessarily think about off the top of your head about what's happening with that. I've been in companies to where, the payroll department has had like file cabinet after file cabinet filled with the thick, what used to be the thick reports they would get every pay period. And so it would just take up an enormous amount of space. And now we can get a lot of these reports, or I think everybody does these days. They either get them online, or they can just go in and look at the reports in the payroll system. And so they're not thinking about holding on to that stuff. But companies tend to move around a little bit with payroll companies. And I think it's important to not assume that your payroll company is holding on to those records. When I first heard about this, I went and started asking questions. And even if you didn't change payroll companies, a lot of those payroll companies didn't hold on to records longer than 3 years. It's like, oh no, that's their responsibility if they want to keep the records longer than that. And so pay attention to that. Just because you're using the same company, or that they've told you that, their policies also change. And particularly if they've had to do it, in the old paper style, a lot of them have not kept those things. And if you change payroll companies, usually you're going to have to pay to have them hold on to the records. And even then, it's not necessarily going to be forever, even though, it's like, well, as long as I keep paying, they'll hold on to them. Things change. Ultimately, you need to be responsible for those payroll reports, because you're the one that's going to get those questions about the pay, whether or not the time cards even were kept. I mean, I've got some clients that keep time cards in the employee files, which I don't care for. I would rather you set up a separate payroll file, even if it's the same person doing it, because I want to have the time cards in my ideal. What works best for me, let's say, is that the time cards are kept in the folder for that week's reports. Or if they're scanned online, they're all kept together, because inevitably when you get a question or a claim, it's going to be looking for the backup for particular paychecks. And so it just makes it easier in my mind, but I know different people have different ways they do it. But you need to be able to go and look that up, because as you've seen, you know, with some of those examples I originally gave, these lawsuits come in way later. And even though you might think your payroll company holds it for 3 years, what if the claim is taking longer than that? And now when you go in to start pulling those records, they're no longer there. So make sure that you've got a sufficient amount of years of proof for anything that you've done for payroll reasons, because money makes for lawsuits. And so anytime someone thinks they're not getting paid, you know, correctly, things like that, you want to be able to have the backup available. And generally, you have to hold on to that stuff for 4 years. So even the 3 years, which is some states, you know, again, pay attention. And if you can digitize them to where you can just keep them somewhere in a drive, then do that and hold on to them for much longer. Wage records. So this is the time cards, the things that you've done, the W-2s, all the stuff that's going to come back, you know, piece rates. Piece rate pay has come under fire several times in California to prove that it's being done correctly, because we have, you know, we're like the only state that has these required rest breaks and things like that. But you want to take a look at that. And I think these days, you know, the equal pay thing is becoming a big one, that you need to go back and be able to look and say, what are the wage differentials for people in a similar job? Because some of the laws now, it's not just, you know, men and women for the same job. It's that level position. If you happen to have a pay scale that shows, okay, grade 5 is this level of managers, well, regardless of what the department they're in, you would have to be able to prove that their pay is equal across that pay grade, or similar at least, and be able to back up what the differentials are. So there's, like I said, when there's money involved, there's more likely to be lawsuits. And yes, the attorneys are the ones telling me that they benefit most from those claims, but the claims are still out there. And to make sure that you look closely at your pay stubs, your wage statements, whatever you're calling them, but take a look at them, because I have seen lawsuits where somebody who had same company name, same address for 40 years, suddenly, like 3 years ago, it must have been a blip in the payroll system, but a word was dropped out of their name and the city was lost on their pay stubs. And depending on what your state does, but California looks at this and says, oh no. You know, and the attorney that's dealing with this is dealing with a $2 million claim, because the only correction possible in California for that is you have 33 days to go back and replace every single pay stub for every single employee that had something wrong with it. Look at your state, see what they're doing, but you can see now how seriously even that pay stub and what information is on there counts, because you're relying on that to be your backup. All right, our next polling question.
Do you keep workers' comp claims in the employee file? This is a pretty simple yes or no, so I want to see 100% of the people voting. And while we're getting there, CJ, we had a couple of follow-up questions from the last polling question. If you change payroll companies, what are the records you should download and keep?
I would keep basically those reports that you get every pay period. I mean, ideally, you would get the per pay period reports, because that's going to be able to isolate exactly how many hours the employee was paid for that pay period, and then the end of the year reports. that give you more the summary, because if you're ever filling out one of those verification of employment forms, you know, because somebody's trying to get a loan or something, you need to have just that annual amount. The end of the year pay period won't necessarily show the same exact thing. It should, but it may not. But I would say you want to be able to have per pay period to show, okay, this pay period, no, you were paid for this many hours, and the next pay period you were paid for this many hours, things like that.
Okay. Okay. And if you destroy an employee's file, what is your responsibility when it comes to providing a reference for the former employee? If you no longer have the information on the former employee, how do you provide a reference?
Well, you're not legally ever required to provide a reference. So that's not, it's kind of a moot thing. You know, and if you want to, I mean, if you're destroying the records and you can't do it from an official standpoint, then that employee needs to talk individually, like with whoever was his manager, something like that, and ask that person to provide a personal reference based on the work.
Okay. So the results of our polling question, 23% said yes, and 77% said no.
Well, that's good, you know, because I mentioned this at the beginning for the medical file. And so there's different things. I mean, the workers' comp is a medical thing because it's going to say, I mean, everything from stress, and they're going through, you know, counseling, stuff like this. So that's why you don't want it to be part of their normal file, because if the manager comes in and says, hey, I need to see the file, he might be just looking to see what their performance reviews were, a new manager particularly. I want to see what their history is with the company, but he should not see the stuff that you're going to get on doctor's notes and things like that through workers' comp or any other kind of leave. And so that's why it should be carved out and put in a different file. Still just put their name on it, but put medical next to it so you know that's their medical information. And when you look at the employee benefits in general, you can see there's a much bigger retention period on this than we had previously with any of the other documents. And that's because these things, you know, I've had cases that come back 2 years after the employee has left because now they're citing cumulative trauma and want to refer back to something that we had in the file. And, you know, and so it's different kinds of stuff that pop up, that looking at the kind of stuff, the beneficiary designations, eligibility determinations, especially if it was something odd, the, you know, proof of COBRA notices. Now, if you're using a third-party administrator for your COBRA, fine, you know, but you should still make sure there's something that you've put in the file as far as even requesting it, because even if you're using a third-party administrator, legally, you are still being held responsible for making sure that that employee received those COBRA notices. So do you have any checks and balances in place to make sure that your TPA is in fact sending those out when you've requested them? Summary plan descriptions. These things kind of change, and some of it may even be things that you keep, like, oh, here was the insurance we used to have. Because I've done that before and had requests for it, to where I just keep my policy information for a long period of time, not necessarily even the employee information. And to look at that. And for retirement business, you know, benefits, you got the 401k, or you've got some other kind of, you know, SEP plan, something like that, or even pension plans. You want to hold on to those records forever. And because that's all, you know, it's a long-term thing. You're holding on, if you're providing those or having determined what they're getting in retirement, then you're needing to do long-term backup for knowing that they are getting the right amount. So there's a lot of different things there in that, and definitely kind of shows you where it just keeps popping up that these things come back. And that's why, you know, if you're thinking, instead of trashing it or shredding their file, scan it. These days, it's not that costly to get a secure, you know, place to store those digital files. And they don't take up any extra space. They cost you just a little bit each year, and it's worth it to have it and know that you've got the comfort of knowing all of that information is being held onto if it should ever be needed. Insurance applications. ADA, I mean, medical, this is again that medical file, the information. It used to be, like I said, they used to, especially for small companies, a lot of times employees would have to fill out this health questionnaire to see if they would qualify, if enough people qualified for the group insurance. It was weird. Now we don't have to do that. But you may have been around, the files may have been around a very long time, and you may still have some of those in the files. So take a look at what's in there. If you've got employees that have been there for like 15, 20 years, they may have had to do that at some point in time. Medical records, things like that, again, keep it confidential in a place that isn't where someone's going to come and yank out the personnel file. FMLA. That you want to hold on to for 3 years, because we've got those 1 year either look back or look forward and all this kind of stuff. But you need to be able to again, back up and show when they've used FMLA if you're subject to that. And that really kind of goes these days for any of the leave laws that are legally mandated. In California, we've got CFRA, which is the California Family Rights Act, that's very similar to FMLA. We've also got now new parent leave, different things like that. You want to be able to track all that, but you do need to legally hold on to it for at least 3 years. Let's go for our last polling question.
Okay. What do you do with records from an internal investigation? Do you keep them in the employee's file, keep them in a separate file, the attorney keeps it all, or trash when the investigation is over? And while we're waiting for the respondents to answer that, we have one question. Are we supposed to receive a copy of the COBRA notices that are sent to the employee by the provider?
Normally, companies don't get a copy of it. So, what you need, I know, which makes it harder to do the checks and balances, doesn't. What I would do is instead set up a little process to where, I always, when I'm terminating somebody and I know they've had the insurance, it's like, okay, within, your insurance runs, what is this, June 4th? Okay, your insurance runs until June 30th. And within 2 weeks into July, you
DJ, we lost you there. Are you still there? Okay, we're going to have to wait for CJ to come back on the line. She probably lost her connection, so she'll be dialing back in. And while she does that, I'll just remind everybody that all of these presentation materials will be available on our website after the session today, aspenrmg.com/Heffernan-webinars. And I will be sending that URL out by email, so don't feel like you need to write it down right now.
okay. Am I back online?
Okay, now you're back. Okay, thank you.
Goodness. It's like, I know, somehow I lost, and then I couldn't even hear you for a while, so I kind of had to reconnect with the webinar.
Yeah.
Okay, so typically you don't get a copy of the COBRA paperwork as a company unless you're the one sending it out and you keep a copy. Mm-hmm. But what you do is when someone terminates, make sure they understand when they should get that paperwork and to contact you if they haven't received it. And then periodically you could just do a random check. It's like, oh, Sally, I just wanted to make sure that you received your COBRA paperwork, so that you know it's going out there, and confirm with the company or whoever's sending it out what their timing is. Do they send it out as soon as you've notified them? Do they wait until the insurance is ended? Something like that, so that you have a better sense of when the employee should be able to expect it.
Okay, and the results of our polling question: 11% say keep it in the employee's file, 84% keep it in a separate file, 5% say an attorney keeps it all, and thank goodness nobody trashes it when the investigation is over.
Oh, goodness, yeah. So as a rule, investigations, I put them in a sealed envelope and put them in, I will, that's when you want that legal file, because often, not always, but often an investigation included talking with your attorney. And again, you're looking for that client-attorney privilege. But if you haven't been talking with an attorney about that particular investigation or claim, then put it in a sealed file, anything you've got, and put on there that it's confidential, do not open, only HR can open it, something like that, or only the CEO, whatever works in your company and the size of your company. But, it's like I'm hesitant to keep it in the attorney's file simply because you might change attorneys. You're usually not the person choosing the attorney for the company. So if they shift out to a different firm, suddenly, your backup is over here and they're probably going to charge you to get a copy of it. So take a look at that as, again, who's holding on to it, or again, if you truly have a secure place to put this stuff online digitally, you could scan it all when you're done with it and put it in there. But even then, I would probably password encode it and make sure that you've got some way of people in the future being able to open it again if need be, because you don't want a manager to just blindly go in and be able to see what went on in an investigation. They don't have that right. They get, if they're not involved in the investigation, then they just might hear the results of it, something like that. And legal claims, the legal claims come in a lot of different formats. As we all know, it's like I'm in California. In California, we continue to get, I can't remember, I think it's the New York Magazine or something that has awarded us more than 1 year in a row here for being the most litigious state in a very litigious country. And so, depending on your state and how litigious people are there, it's really important to hold on to anything you've got that could be considered backup. If you think about it, nowadays when people are filing claims, immediately, if you talk to your attorney, they're going to tell you, okay, make sure nobody trashes, shreds, deletes any emails, even on your email, in your email system. It's like you are no longer allowed to go in and clean out things. That is now protected by the courts. And as soon as that claim comes in, it's like, oh no, you don't touch anything you've got that was from or about this employee. And so keep that in mind. Where's all that stuff going? Does your IT staff know that? I've seen, terminations happen to where IT's in there like completely wiping them off the map the second the person's being terminated. And you can't really do that anymore. You need to, again, have a place for that stuff to go. And IT isn't necessarily, just like payroll, depending on what kind of training they're getting, they may not know what we'll call HR rules are about these things. So it's up to the HR person to make sure everybody else knows what you're going to need and what they need to hold on to and how it's going to be held on to, and to take a look at that kind of stuff. So then we've got all those miscellaneous things that inevitably show up in a file. I-9, as I said, you have to, I keep those in a separate file just in case you're audited. And but they need to be held on to for the latter of 3 years from hire or 1 year after term. And actually, if you go online where, all the, I think it's UCSIS, their site that, talks about all this, that's doing the Homeland Security and everything and the immigration, they actually have rules even when you rehire somebody on whether or not you need to redo an I-9. And so take a look at that, because if someone is rehired within, I think it's a year, you don't have to have them fill out a new I-9 unless their documentation has changed, things like that, but you want to make sure it's all still current. I actually have had several clients looking for information and hiring what they consider child labor, which is anyone under 18. So a lot of times you might get that high school student, and at least in California, the process is there's a form that they need to have the school fill out, the parents fill out, stuff like this, that they need to have in there. And then there's very specific rules about how much and when that child can work. And you've got that kind of documentation you want to hold on to. You've got union and employee contracts that you need to hold on to for at least 3 years. And I would say it's 3 years after that contract is no longer valid, because while it's still valid, it's sometimes a moving target. Every year there might be the contract renewed or something like that. But you want to look at the history, because if something came up talking about maybe the sick leave or something like that, and it was actually mentioned in a contract that was 2 years ago, you need to be able to pull all those pieces together and say, oh, look, no, based on the union contract, which often will override state laws, the union contract said we didn't have to pay this person for their sick leave. even though the state law might have said you are paying for sick leave. So you need to have, again, it really does I can't talk, mean you have to sit down and think about your different policies and what touches those and what could, be something that you needed as backup if there was ever a claim about that particular situation. If you're large enough, there's the affirmative, I know now we've got new EEOC reports, but the affirmative action program that you've got, it's only if you've got 100 or more employees. But if you've got that, it is a program, and you have to go through it periodically and make sure that it's up to date, and to take a look at that and to see if what you've got, and there's probably other things that you're doing that I didn't put in here. I have a client that works with the Department of Defense, and they had me come in originally and help them go through their personnel files. But they first had to go through them and pull out all the stuff that was DOD related, because I was not authorized to see it. So they have their own division of what anyone can see. You had to have, security clearance in order to see that part of the file. And, so again, look at that. Look at the different things that you're doing. What, if you're a federal contractor in any way, is there anything in that contract that relates to what happens with an employee's file? And then find out what are the rules. But as I said, overall, it seems to me the safest thing is to scan them, put them somewhere where they're safe. And I don't recommend putting them on a DVD, because DVDs can get broken, melted, lost, end up in somebody's house that sets on fire. Who knows? There's different things like that. There's a lot of online resources that are quite inexpensive overall for storage, and to make sure that only certain people can access that, so that you know what it is. If it's, password encoded, I would keep a sealed envelope with the password in, like the HR file or something like that, or maybe the CEO keeps it. And to where, all right, if somebody needed to go and that person's no longer around, how can we get into this system? And because we've all had employees terminate, and we're like struggling, IT's having to just wipe out some of the stuff in order to crash through their system because they put a password on there that we didn't get when they left. So take a look at all of it. If a record is listed in more than one of the categories, you have to keep it for the longest period total. So, and ironically, the pension plans, the retirement plans, those were the forever ones. So, that information at least needs to be kept that long. But again, look and see how it works with the rest of your files. And nowadays we are lucky that we don't. I have worked in companies a long time ago where literally, and ironically, of course, they were putting their old, I got hired into a company, and I looking through the records and stuff and looking for an employee who'd left or something, and it's like, oh no, that's in the warehouse because it's an old file. They were boxing up their old files as they should. Since we weren't back at that time, it wasn't as popular or as easy to turn those into, scanned documents, but they were boxing them up and putting them, literally, they had a section in the warehouse. They weren't locked boxes or anything, and they were just in the warehouse. And it's like, oh my gosh, this is what happens when you don't pay attention or think it through. And there's a lot of companies that have that. They, at most, they might have put tape around the top of the box, something to keep you from just accidentally lifting the lid. But if it's out there in the warehouse, how long would it be before someone would go out and check that everybody's box was still sealed? Things like that. Take a look at what you've got going on and fix it if it needs to be fixed. And actually create retention policies so that all of the employees know not to clean house when someone leaves. I've seen that way too often, to where now you can't access their emails or their files. I've seen employees, which is a hard thing to do if you're having somebody, particularly if they resign and they're not leaving immediately. I have seen often where they will go in and clean out their desk with any files they had in there. They go in and clean out all their emails to make sure there was nothing personal. And it's like they can't do that anymore. It's illegal. And so as soon as you hear someone's leaving or that you know you're going to fire somebody, you need to make sure everybody involved knows what the retention policies are. And as I've mentioned before, I've talked to more than one attorney who just recommends keeping those files for the life of the company. And I don't know, like a 20-year-old file, how useful that is, but you don't know. And that's our biggest problem in HR is we don't know. Laws change, new laws come in, things like that, and we're the ones having to provide the backup. So that's the end of today's. I've got a few more minutes if there's any other questions.
We do have a couple of questions. If your workers' comp TPA says that the HR department can destroy files and records because the work comp TPA is the record keeper, is it good practice to really destroy the files?
No. You're trusting that outside company, but they're not going to be held responsible. You will be held responsible. So you want to be able to make sure that you've got files. It's great that they're holding on to them, but ultimately when it comes down to a lawsuit, you're going to be the one on the end of the lawsuit.
Okay. And how long should you keep certified payroll reports?
I think I can't say I'm aware of what the time frame on certified is, but I think because you've had to certify them, and that's usually something that happens a lot with the construction industry, is that they have to do certified. But because a lot of times you're doing certified records because you've got a state or a federal contract, then again, you're going to want to keep them a long time. I mean, I would probably kind of go for the forever, but I would say at least, I'd probably just do a guess of at least 7 years of trying to keep something, because the government comes in, like I said, IRS can go back 7 years, so I'm not sure that a certified payroll couldn't be hit with that.
Okay. And last question, what law is it that we can reference that says that we can't delete files on email?
Well, I am not sure there's a specific law for it, so much as what the courts have come up and said is that now there might be, if you have an employment law attorney, I would ask them if there's actually a specific law. I know it's always going to be referred to because companies, I think, in court have taken a hit because the records were destroyed. And so that's where it's coming from. Yeah, so it's more of a best practice. I'm unaware that there's a specific law citing that, but I do know that companies have been hit in court for having destroyed those records, because bottom line is the court and the jury is going to believe you had something to hide if you destroyed records.
Okay. And one last question came in, but I think we've already answered this, but it may need some clarification. W-4s and direct deposit paper files, can we scan them? So it comes back to electronic versus paper question.
Yes, you can scan those. I mean, the only thing I once told people to hold on to the paper copy was something that you really needed, that wet signature, the actual document with the real signature, and that, so like an arbitration agreement or a non-disclosure, that if you were hit with an, proprietary information kind of lawsuit, or you were going after the employee, you might want that. But nowadays, and I think that would be one to check with your attorney in your state on where that's going in court. It seems to me that a lot of the digital stuff is making its way through court now, and even the digital signatures are working. But I think, again, with the digital signature, you have to be able to prove that only that employee could have signed that document digitally. And so it kind of goes back to the safeguards you've got and the passwords and everything.
All right, very well. So thank you everyone for attending today's webinar presented by Heffernan. We will send information by email with instructions on how to access a copy of the presentation on our website. Thank you, CJ Westrick, for your time and expertise today.
Thank you.
We hope all of the attendees found today's webinar to be a valuable use of your time. So please be sure to join us on June 25th for Ergo Healthy Topics, Office Ergonomics, the Basics and Beyond. Thank you and have a safe day.